I request everyone to kindly maintain silence and be seated as we await the arrival of our guests. Check, 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 mic check. I request everyone to kindly maintain silence. We are awaiting the arrival of our guest. They'll be arriving shortly.
Dear faculty, we invite you to occupy the front seats. Other than the class teachers who will be sitting with their classes, all other faculties kindly occupy the front seats that are reserved for you.
Hello. 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 1, 2, 3. Check. Check. 1, 2, 3.
Sir, can you hear whatever is?
Yes. Yes, I can hear.
quick reminder. Students are not supposed to use their phones during the session. And also please note, nobody is allowed to go for washroom breaks in between the session. I request everyone to kindly maintain the silence. I request everyone to kindly rise and welcome the dignitaries. Thank you. Kindly be seated. As rightly said, when justice is upheld and the rule of law prevails, societies flourish with dignity, accountability, and peace. Good morning, everyone. It is with immense pleasure and great honor that I welcome all the dignitaries, distinguished guests, respected faculty members, scholars, and participants gathered here for Meliora 7, the International Conference on Contemporary Challenges to Governance and Rule of Law. As the name Meliora signifies, towards better things, this conference stands as a platform for intellectual exchange, critical reflection, and meaningful dialogue on some of the most pressing legal and governance challenges confronting the contemporary world. Through this conference, we hope to encourage conversations that inspire awareness, understanding, and responsibility towards building a more just and accountable society. Today, we are privileged to be in the presence of eminent academicians, legal luminaries, and distinguished dignitaries whose insights and experiences will undoubtedly enrich the deliberations of this conference. Before we formally commence today's proceedings, let us begin by invoking the light of knowledge, wisdom, and truth that guides every meaningful pursuit of learning and justice. The ceremonial lighting of the lamp symbolizes the removal of ignorance and awakening of understanding, values that remain at the heart of law, governance, and education. To mark the auspicious beginning of Meliora 7, I now request our esteemed dignitaries to kindly come onto the dais and proceed for the ceremonial lighting of the lamp. Thank you, dignitaries. I request the dignitaries to kindly take their seats on the dais as we proceed further with the inaugural session. Coming together is a beginning, staying together is progress, and working together is success. As we gather here today for Meliora 7, we come together with a shared purpose: to engage in meaningful dialogue, exchange ideas, and reflect upon the contemporary challenges to governance and the rule of law. It is the collective spirit of learning and academic excellence that gives true meaning to conferences such as these. To formally commence the proceedings of this conference, I now invite Dr. Nandu Sam Jose, Convener, Academic Outreach Committee, Christ Academy Institute of Law, to deliver the welcome address.
respected dignitaries, delegates, faculty members, and dear students. Good morning to one and all. It gives me immense pleasure to extend a warm and gracious welcome to this august gathering assembled for Meliora 7 International Conference on Contemporary Challenges to Governance and Rule of Law, organized by Christ Academy Institute of Law. At the outset, I respectfully welcome our distinguished chief guest, Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State University. Your gracious presence adds great value and inspiration to this occasion. I extend a heartfelt welcome to our guest of honor, Professor Dr. Sathish Gowda N., Dean and Professor of Law, Bangalore University, and Syndicate member, Karnataka State Law University. Thank you for joining us and supporting this academic endeavor. I also warmly welcome our esteemed keynote speaker, Professor Kirk W. Juncker, Professor of Law and Vice Rector of Sustainability, University of Cologne, Germany. We are honored to have an academician of his repute joining us online today. I take this opportunity to respectfully welcome Father Thomas Chakramakal, CMI, Manager, Christ Academy Group of Institutions, whose constant encouragement and visionary leadership continue to strengthen the academic culture of our institution. I also extend a cordial welcome to Professor Dr. Father Davis PV, CMI, Principal, Christ Academy Institute of Law, whose unwavering commitment to academic excellence has made programs such as this possible. A special welcome is extended to Dr. Cini John, Vice Principal, Christ Academy Institute of Law, for her dedicated support and valuable contribution towards the successful organization of this conference. A warm welcome is further extended to all dignitaries, academicians, researchers, legal professionals, faculty members, students, and participants joining us from different parts of India and abroad. The theme of this conference, Contemporary Challenges to Governance and Rule of Law, is both timely and significant. At a moment when democratic institutions across the world face unprecedented pressures from the rise of digital authoritarianism to the erosion of accountability mechanisms, to the tension between national sovereignty and global legal norms, this conference could not be more timely. The questions we will explore over these 2 days are not merely academic. They are the questions that will shape the kind of society our students will inherit and the kind of lawyers they will become. We sincerely hope that the deliberations and discussions over the course of this conference will contribute meaningfully to legal scholarship and policy discourse. Once again, I welcome each of you to Meliora 7 and wish you a fruitful, engaging, and intellectually enriching experience. Thank you.
Thank you, sir, for your warm words of welcome and for setting the tone for this significant academic gathering. Your words have truly reflected the vision and purpose behind Meliora. It is now my privilege to invite Reverend Father Thomas Chakramakal, CMI, Manager, Christ Academy Group of Institutions, to deliver the presidential address.
Respected dignitaries, honored guests, dear faculty members, participants, and beloved students. It gives me immense pleasure to extend my warm greetings to all gathered here for Meliora 7 International Conference on Contemporary Challenges to Governance and Rule of Law, organized by Christ Academy Institute of Law. I consider it a privilege to preside over this inaugural session and to witness such a remarkable congregation of legal scholars, practitioners, researchers, and students committed to intellectual inquiry and social transformation. At the outset, I congratulate the Academic Outreach Committee, the Principal, Dr. Father Davis P.V., Vice Principal, Dr. Sini John, Convener, Dr. Nandu Sam Jose, faculty members, student coordinators, and volunteers who have worked tirelessly to make this international conference a reality. The theme chosen for this conference is Contemporary Challenges to Governance and Rule of Law. Although this theme may appear contemporary in its expression, however, the quest for governance under the rule of law is, in reality, an evergreen human inquiry. From ancient civilizations to modern constitutional democracies, societies have continuously grappled with one enduring question: how can governance be made more just, accountable, humane, and effective? And in particular, how to safeguard the governed from arbitrary, unjust, and whimsical decisions of those who are governing them. This inquiry has existed since time immemorial, and it will continue to guide humanity in the future as well as new social, technological, and global challenges emerge. We are living in an era marked by rapid technological advancement, conflicts emerging across the world, shifting political realities, environmental uncertainties, widening socio-economic disparities, and evolving understandings of rights and justice. Hence, the principles and ideals of good governance and the rule of law must be reviewed, reflected upon, recalibrated, so that they respond to the contemporary needs of humanity with a fairness, accountability, compassion, and inclusiveness. The rule of law is not merely about legal compliance. It is about safeguarding human dignity. True governance is not measured only by administrative efficiency, but by the extent to which institutions remain transparent, democratic, and responsive to the marginalized and vulnerable sections of the society. As future legal professionals and scholars, all of you carry the responsibility of preserving constitutional morality, defending justice, and strengthening democratic institutions. In this context, the recent emphasis by the Department of Justice, Government of India, on the idea of ease of justice becomes particularly relevant. Ease of justice is not confined merely to faster courts or digital access to legal systems. It fundamentally depends upon the quality of governance and the strength of the rule of law within institutions. Rule of law provides the foundation for ease of justice, good governance, minimizes injustice before disputes even arise, while an effective justice system ensures remedies when governance fails. Therefore, discussions on governance and the rule of law are ultimately discussions on improving access to justice itself. When governance becomes transparent, accountable, participatory, and citizen-centric, justice becomes more accessible, affordable, and effective. Likewise, when the rule of law is strengthened, arbitrariness is reduced, institutional trust increases, and individuals are better empowered to realize their rights and remedies. Ease of doing business and ease of living cannot be achieved without ease of justice. I am particularly happy to note that this conference brings together diverse discussions on constitutional governance, environmental justice, digital governance, artificial intelligence, labor rights, criminal justice, corporate accountability, and international law. Such interdisciplinary engagement reflects the evolving nature of legal education and the growing need for holistic approaches to contemporary challenges. In educational institutions inspired by the values of the CMI tradition, we believe that education must shape not only competent professionals, but also socially conscious human beings. Knowledge acquires meaning only when it contributes to the welfare of society. Therefore, conferences like this are not merely academic exercises, they are platforms for dialogue, reflection, innovation, and nation building. I also take this opportunity to appreciate the cohort of scholars and students from various institutions across India and abroad who are participating in this conference. Your presence enriches this academic platform and strengthens the spirit of collaborative learning. I encourage every participant and paper presenter to use this conference as an opportunity to exchange ideas, challenge assumptions, and contribute constructively toward legal and policy reforms. As we inaugurate this conference today, let us collectively reaffirm our commitment to justice, ethical governance, constitutional values, and academic excellence. With these words, I once again welcome all the dignitaries, speakers, delegates, and participants to this prestigious conference. I wish the deliberations great success and hope that the discussions over the next 2 days will be intellectually enriching and socially impactful. Thank you.
Thank you, Father, for your inspiring and thoughtful address. Your words have greatly enriched this gathering and beautifully highlighted the importance of knowledge, values, and responsibility in today's world. Your encouragement and guidance have truly set a meaningful tone for the conference and inspired all of us gathered here today. Education is not merely the pursuit of knowledge, but the shaping of values, vision, and responsibility. An institution grows through the leadership, guidance, and the commitment of those who inspire its academic and professional journey. At Christ Academy Institute of Law, this vision continues to encourage students towards excellence, integrity, and meaningful contribution to society. It is now my privilege to invite Professor Dr. Father Davis PV, CMI, Principal, Christ Academy Institute of Law, to address the gathering.
Good morning, everyone. Hon'ble Vice Chancellor, Prof. Dr. Basavaraju, sir. Father Manager Thomas Chakramakil, and Prof. Dr. Sathish Gowda, special guest, Dr. Sini, Dr. Nandu, my faculty members, and my dear students and participants even from Hungary and Sri Lanka. Let me take you to an incident which took place 2018 in Kerala during we deliberate on the contemporary subject, that is contemporary challenges to governance and rule of law. Have you heard of a tribal man, Youth Madhu? Last Monday, the High Court of Kerala affirmed the conviction and raised the term of punishment to life imprisonment for 13 criminals in Kerala, so-called educated state in India. Madhu, 30 years old tribal man who has stolen rice worth 200 rupees. Mob handled him. Among the mob, we can see so-called leftists also there. Those who are advocating for the poor people. And he was almost about to die and taking selfie. Mob violence and taking selfie handed him to the police. Police took almost 1 month to start the enquiry in a so-called educated state in Kerala. It took almost 5 years. The trial court convicted 13 criminals to be declared criminals and then convicted for 7 years punishment. Then later, after 3 more years, the High Court of Kerala reaffirmed the conviction and raised the term of punishment to life imprisonment. And we are deliberating on contemporary challenges to governance, the rule of law, sitting in AC auditorium. This is the maybe a point to be discussed. And that is why maybe a literacy on constitutional mandate shall be discussed. Literacy on rule of law shall be discussed. And literacy on how the governance shall be discussed. And with that vision, we have a guest here in the person of Hon'ble Vice Chancellor, Professor Dr. Basavaraju sir here. I think this is the Karnataka State University, the biggest law university in the country. And maybe the time, the task he takes to go to the centers of legal education, to visit, and he becoming from a good teacher to the best administrator. And I have seen him maybe visit in the valuation center, maybe there all of us face an issue at some time, But every valuation center, he takes time to go there, visit, and tell the teachers, be proportionate, be diligent. That is his personality. And then I know when he meets the principals of Karnataka State University, he was so much with admiration and telling about the quality of the education. The quality of the education. And always, he has seen him very simple. That is why he is worth to be called Honorable Vice Chancellor. And then for the first time, I met him during the principals meeting. First time, me and Dr. Sini met him during our difficult time. The first sentence he made to us, the Christ Academy Institute of Law is the best law institute in Karnataka State University. That is why I took a time to resolve this matter. That is a personal attention. Because he has a vision and plan. The best institution shall not be destroyed by any one of the persons, those who may not follow the rule of law in the country. That is his vision and mission. Always he is so particular, the quality of the education. That is why many times he very sharply speaks to the principals, no, every day there shall be academics. And internal assessment shall be there. That is my recent syndicate meeting. He has taken initiative to constitute a new committee under the leadership of Professor Dr. Sathish Gowda to maybe look into the internal assessment system. And he believes then only the quality of the legal education shall be there. Maybe to have a literacy on rule of law, we have introduced, I was discussing with Honorable Vice Chancellor Nyaya Shraddha, and then this time I proud of you all because each one of you has taken a good time to have the creative program in the villages. the villages nearby this institution. And we are having the Shraddha for the community where we live. Then only the consciousness of rule of law will be implemented in our mind and heart. And then secondly, let me appreciate Professor Dr. Sathish Gowda. Always I used to come for the LIC here, but especially LLM. He used to tell, this is my institution. Only because of his interest, I think we tried Hon'ble Vice Chancellor to be here since almost 2 years back, but we could not succeed. But this time, only because of Professor Dr. Sathish Gowda, we could made that dream to be possible, a giant in legal education to be here. And let me thank Professor Dr. Sathish Gowda, sir, to make this event to be more colorful in the presence of Honorable Vice Chancellor. And let me congratulate Academic Outreach Committee for organizing two-day conference. Almost more than 150 papers are there. And then we have participants from India and outside India. For the first time, we are having the participants from outside India. And I wish these 2 days shall be a time to deliberate and implant the heart where the consciousness of rule of law and good governance shall be planted in the heart and mind and body of ours. Thank you so much.
Thank you, Father, for your encouraging words and continued guidance. Your unwavering commitment towards academic excellence and holistic legal education continue to inspire the entire student community. As a gesture of gratitude and respect for the presence and valuable contribution of our esteemed guest, we shall now proceed with the felicitation ceremony. May I now request Reverend Father Thomas Chakramakil CMI, Manager, Christ Academy Educational Institutions, Professor Dr. Father Davis PV, Principal, Christ Academy Institute of Law, the Vice Principal, and the Faculty Convener, Academic Outreach Committee, to kindly felicitate Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, Hubballi. Sincerely thank Professor Dr. C. Basavaraju for gracing this conference with his esteemed presence. May I now request the dignitaries to kindly felicitate Professor Dr. Sathish Gowda N., Dean, Faculty of Law and Professor, Bangalore University. Sincerely thank Dr. Sathish Gowda N. for his valuable presence and association with this conference. Thank you, dignitaries, for doing the honors. We shall now proceed further with the inaugural session. Great leaders and academicians inspire not only through their achievements, but through their knowledge and vision they share with the society. As we prepare to hear from our esteemed chief guest, let us first take a moment to acknowledge his remarkable journey and contributions. Before we move to the inaugural address, I invite Ms. Kushi Kumari, Student Co-Convener, Academic Outreach Committee, Christ Academy Institute of Law, for the profile reading of our esteemed chief guest.
Good morning, everyone. It's my privilege to introduce our esteemed dignitary, Professor Dr. C. Basavaraju, who is presently serving as Vice Chancellor of Karnataka State Law University, Hubballi. Professor Basavaraju is a distinguished academician, eminent legal scholar, and an able administrator with decades of contribution to the field of legal education and social justice. Over the years, he has held several prestigious positions, including Vice Chancellor, Registrar, Syndicate member, and Academic Council member at University of Mysore. As a committed scholar and dedicated law teacher, he has begun his academic career at renowned National Law School of India University in 1995 and later served the Department of Studies in Law at the University of Mysore in various capacities such as professor, chairman, dean, and head of faculty of law. His academic excellence is reflected in his vast scholarly contributions, including more than 125 research papers, 4 significant books, and presentations over 175 national and international conferences and seminars. Professor Basavaraju's area of research primarily focused on social justice and constitutional law. He earned his PhD from University of Mysore on social justice with special reference to SC and ST under Constitution of India. He has also successfully completed major research projects funded by University Grant Commission, New Delhi. His academic contribution extends beyond India. He has represented Indian legal academia internationally by presenting research papers in countries such as Poland, Bhutan, Dubai, and China. His presentation at International Conference in Poland on environmental best practices and the role of judiciary earned him the Best Paper Presenter Award. His remarkable service and dedication have been recognized through various honors, including the Best Citizen of India Award, National Integration Award, and RTI Awareness Award. Beyond academia, he continued to work actively for social justice, national integration, and upliftment of weaker and vulnerable sections of society. Today, we are truly honored to have an eminent scholar, visionary academic leader, and socially committed personality among us. I extend a warm and heartfelt welcome to you, sir. Today, it's my great honor to invite Professor Dr. C. Basavaraju, Vice Chancellor, Karnataka State Law University, Hubballi, to deliver the inaugural address.
Good morning to one and all. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Respected Reverend Father Thomas Chakramakil, Principal of this college, Professor Fernandez Davis, my dear student and today's guest of this function, Professor Sathish Gowda, convener of this academic outreach committee, Dr. Nandu Sam, vice principal of this Christ Academy Institute of Law, Dr. C.N. John, teachers of this great institute, my dear students, delegates, participants, all the invitees, members from the media, ladies and gentlemen. Today, I am so happy to inaugurate this program, International Conference on Contemporary Challenges to Governance and Rule of Law. There are two important issues which have been confronting us, not from yesterday, not from recent past, from the day when the Constitution came into force. January 26, 1950. That is, how to ensure governance and rule of law. The question of governance and rule of law is not a recent concept which we have been discussing in different platforms, in different conferences and seminars. There are many problems which we are all confronting from the day one of the Constitution came into force and even prior to the Constitution. Look at the social problems which we have today and which we had earlier to the independence of India and the Constitution came into force. When we speak about the governance, when we speak about the rule of law, we are always reminded of a great scholars, social reformers who have fought for justice, equality, equity principles, and transparency in governance. Being the students of law and belonging to the legal fraternity, we should look into the word governance in the Indian Constitution. The makers of the Indian Constitution deliberately included the word governance in the Constitution of India. It is not provided or encapsulated in the part 3 of the Indian Constitution, but it is encapsulated in the part 4 of the Indian Constitution. When the draft Constitution was submitted to the Constituent Assembly by Dr. B.R. Ambedkar, a question which rose on the floor of this Constituent Assembly was, why do we require Part 4 of the Constitution of India, Directive Principles of the State Policy, when we have a Civil Liberties Part 3 in the Constitution, draft Constitution? The civil liberties includes the fundamental rights, what we are discussing over a period of time. When the question was asked to the Dr. B.R. Ambedkar, what is the significance of directive principle of the state policy when you have fundamental rights? What is the significance of this directive principle of state policy if they are not enforceable in a court of law? Dr. Ambedkar said, without mincing the words, he said, directive principle of the state policies are encapsulated and incorporated deliberately by the makers of the Constitution for the good governance of the state. The word good governance of the state, which is found in directive principle of the state policy. Dr. Ambedkar, he went a step ahead and said, I am not insisting for the fundamental rights. I am insisting for the directive principle of the state policy as they are fundamental for the good governance of the state. Directive principles of the state policy, they are fundamental for the good governance of the state. Why do we require good governance of the state today? Or why the constitution makers thought of a good governance should be ensured to the free independent India? If you go back to the history, you find millions and millions of people in this country, even much earlier to the constitution came into force, or independence of India, they were socially discriminated. They were socially outraged. They were totally neglected in the society. The neglected sections of the society wanted equality, wanted non-discrimination. They wanted justice to them. And the makers of the Indian Constitution, they decided that the free India must have social justice. It must ensure social justice to all sections of the society, irrespective of their status, irrespective of the religion, irrespective of the caste, and irrespective of their belief. That was the intention of the makers of the Indian Constitution. They wanted to see that there must be a good governance of the state, so that every individual, whatever may be their religion, whatever may be their caste, whatever may be the community in which they belong, they should have equal due, equal share of the society. If we ask to ourselves today, are we following, giving respect to the constitutional mandate of justice, equality, humanity, liberty? Where do we have liberty? Even after completion of 56 years of constitution came into force? Where do we find social justice? Even after 56 years of constitution came into force? There are many issues which are confronting us even after 56 years. We speak about the rule of law. Once the constitution came into force, rule of law exists. It automatically comes into play. No individual shall be discriminated. No person shall be polarized. Just because an individual belongs to a different sex, different caste, different religion. And the fundamental rights which are endowed by the makers of the Indian Constitution to these citizens of this country, they act as a check or a regulatory mechanism on the state power. State cannot exercise their power arbitrarily after the Constitution came into force. The very fundamental rights, they act as a check or a balance on the state's power. State cannot violate. What is required for this country?
I always remember how the governance shall be ensured within the constitutional framework or institution of the constitutional framework. We do have three constitutional institutions: legislature, executive, and judiciary. Are we looking for the governance, a good governance in these three constitutional bodies? Legislature, which is supposed to make law, an executive which is supposed to execute the laws made by legislature, and the most respected and the most important constitutional institution, judiciary. To what extent judiciary is transparent in ensuring good governance. See, these are all the issues which are confronting time and again. The reason why we do discuss about all these issues, a governance and rule of law, is that the preambular objectives of the Constitution of India has not been fully fructified, has not been fully implemented. Otherwise, if it had been implemented, by this time, the dream of the Constitution makers would have been fructified. And therefore, the governance must be ensured. Good governance can be ensured to the people, to the institutions, through implementation, true implementation of the fundamental rights, true implementation of the directive principles of the state policy, true implementation of the rule of law, and true implementation of the preambular objectives. The preambular objectives. But how to ensure this good governance in the diverse population which India has? India is known for multiculturalism. We are all living in a pluralistic society. Every individual has a constitutional right to follow any religion of their choice. But ultimately, the human concern, the social milieu, the concern about all individuals who are living in the society is much more than anything else. It is not caste is important, religion is important, practices are important. What is important is humanistic approach. How best we will respect the others. How best we will ensure good culture to our people of this country. Good culture always nurtures a good character. There is a need for ensuring good governance, for building the healthy society. Building the healthy society, ensuring good governance, has already been propagated by many social reformers. Gautama Buddha always proposed the good governance. Unless until there is a good governance, there cannot be a healthy society. Subsequently, Basavaraju, in the 12th century, he also in fact imparted the values for the good governance of the state. The only meaning of the good governance is every individual in the society, irrespective of their religion, caste, culture, sex, they must live happily. They must live with pleasure. They must not be subjected to any kind of exploitation, humiliation. We need a egalitarian type of society. An egalitarian type of society where every individual must have access. And therefore, inclusive policy was brought in. So therefore, Basaveshwara said, the real governance can be ensured only when you treat others equally. You can understand the problems of others and try to involve every individual in the decision-making process. The constitutional institutions like Parliament, Election Commission, Public Service Commissions, all constitutional institutions, they must ensure transparency. Transparency is required for the good governance of the state. But it is unfortunate that in many constitutional institutions, we are not seeing the good governance and transparency. There is a need today that transparency, accountability, participation of the people at the decision-making process is very much important. Millions and millions of people who are identified as vulnerable sections of the society, who are oppressed and depressed in the society for a long time, who are neglected by the people, who are sidelined in the main society of the society, they are yet to get social justice. In order to get social justice, there is a need for ensuring proper rule of law. Through proper rule of law, it is possible that governance, good governance can be ensured. We are living in the midst of dichotomy. Even after 56 years of constitution came into force, we are living in the state of dichotomy. Dichotomy between the rich and the poor. Dichotomy between the minority and majority. Dichotomy between the male and female. Dichotomy between various other things. This dichotomy should go. How long we can tolerate this dichotomy? Every individual, every person in this country, they must live with human dignity. And that is why the highest judicial institution in this country time and again has interpreted the very words of the Constitution. Constitution has grown today enormously. It is because of the various interpretations given to the different words which are encapsulated in the Constitution. At the time of submission of the draft Constitution, Constitution was very small. Today the Constitution has run about 13,000 pages. It is because of the interpretations given by the judiciary. Why judiciary is required to interpret? To ensure transparency, to ensure good governance, and to ensure rule of law. If I ask, to what extent the judiciary has ensured good governance through the interpretations? There are plethora of rights recognized by the judiciary through interpretations. Right against handcuffing, right against solitary confinement, right to clean environment, right to have health. There are so many rights have been recognized by the judiciary as a result of the interpretation of various words which are encapsulated in the Constitution. The role played by the judiciary. I am not undermining the role of executive. I am not undermining the role of legislature. But I am only saying that if the legislature and executive fail to perform their constitutional duty, then it shall be the constitutional duty of judiciary to protect the rights of the citizens of this country, including non-citizens. It shall be the duty of the judiciary, and that is why judiciary has been empowered to examine, to review any act of legislature and executive. So transparency can be ensured by interpreting, by recognizing the rights of the individual by suo motu, giving importance to the doctrine of public interest litigation to ensure justice to the people who are unable to approach the courts, who are unable to approach the judiciary to enjoy their rights. I am always reminded of the words, the great words uttered by Justice V.R. Krishna Iyer. In Mumbai Kamagar Sabha decision, judgment, Justice Krishna Iyer has said, the mere enumeration or the guaranteeing of fundamental rights in the Constitution of India is not suffice unless and until there has to be a mechanism to ensure and to implement the fundamental rights. In order to enforce the fundamental rights, there has to be an effective mechanism for enforcing the fundamental rights in case they are violated by state actions. Otherwise, we cannot ensure transparency. We cannot ensure rule of law. Whether this transparency and rule of law is only to govern only the constitutional bodies, constitutional institutions. Ultimately, all these constitutional institutions, they work towards ensuring social justice. They work towards taking the justice to the last man of the society. That is exactly what Dr. B.R. Ambedkar said when he submitted the draft constitution. I will be so happy in this country only when the last man of the society gets justice out of this draft constitution. If the last man of the society is able to get justice out of this constitution, I am the most happiest person in this country. See, that is why the rule of law, that is why the governance needs to be ensured in all walks of life. But unfortunately, in the recent past, new developments are taking place. New challenges are coming out. We are confronting with the new challenges. The social evils. The social evils like the caste system, untouchability, corruption. All these things, they are still in existence. They are still in vogue. Poverty, unemployment, discrimination, slavery, bonded labor system, child marriage. It goes on like that. What is required? There is a need to ensure, enforce, implement the true spirit of the constitutional values. The true spirit of the constitutional values which are encapsulated in the preamble needs to be enforced. Equality should be enforced. Every individual should be treated with humanity. And that is why Article 21 of the Indian Constitution has been interpreted several times to find out those rights which were not found in the Constitution. We did not have a fundamental right to clean environment. We did not have a fundamental right against handcuffing, solitary confinement. But it is because of the true interpretation given by the judiciary to ensure justice, to bring about the rule of law, and also to ensure good governance. Assume that the good governance is not ensured. What would be the consequence? The consequence could be disastrous. Consequence could be disastrous. That is why the fundamental duty of the state is to ensure and to implement all the directive principle of the state policy. Because the directive principle of the state policy, as Dr. B.R. Ambedkar said, they are the fundamental. They are fundamental for the good governance of the state. If you don't want good governance, you just neglect the directive principle of the state policy. But directive principle of the state policy, every principle of the directive principle is so sacrosanct. Needs to be respected, needs to be ensured, needs to be enforced, if at all you want to bring a good governance. In the milieu of good governance, every person, every citizen of this country, they must live without any fear, without any apprehension, without losing any of his rights. And I'm sure there are various issues which are cropped up in the recent past. Is good governance possible under our constitutional scheme? Is there any difficulty in achieving good governance expected by people under our existing constitutional parameters? Are there any needs to have good governance under the constitutional structure? And ultimately, are laws responsible for not promoting good governance? See, these are all the number of questions which are still needs to be discussed and deliberated. It is not the laws which are coming in the way of ensuring good governance. If the laws are coming in the way of good governance, let the laws should be changed. Constitution is flexible in changing the laws to ensure governance, good governance. But at the same time, the constitutional responsibilities have also been entrusted upon constitutional institutions, constitutional machineries. And if they fail to ensure proper administration, if they fail to ensure transparency, accountability, then it is very difficult to promote rule of law, promote transparency. So therefore, the three organs of the government, legislature, the executive and judiciary, all the three are entrusted with the constitutional responsibility to bring about a good governance through enforcing a rule of law. And I'm sure that governance and the rule of law, they are the key concepts needs to be ensured for building a healthy society. But I always hope that it is not the existing legislations, innumerable laws made by the legislative institutions, time and again, can change the entire society for ensuring good governance. Ensuring good governance also depending upon the mindset of the individuals. Because we have already taken 56 years. We have already put into practice the various laws of the Constitution. But still we are talking about the social evils like discrimination, inequality, despite the fact that we have innumerable laws, enactments. And therefore, what is required is that in addition to the existing legislations, there must be a need of respecting the constitutional values, constitutional culture. Human rights culture needs to be inculcated and imparted. And I hope that this international conference will throw a light upon these questions. How to ensure proper governance, good governance, in order to enforce the directive principle of the state policies, which are an integral part for building a healthy society, building an egalitarian type of society, to build a society which is required for all, irrespective of religion, irrespective of the caste, and irrespective of the beliefs and cultures. I take this opportunity to thank the Christ Academy Law College, all the fathers, for having given this opportunity to speak few words on the occasion of this inauguration. And I hope that this conference, in fact, would come out with new, innovative ideas for ensuring good governance. Thank you so much.
Thank you, sir, for your enlightening address and for sharing your valuable perspectives on governance, legal education, and the evolving role of law in contemporary society. Your words have truly set an inspiring direction for the conference deliberations ahead. Every accomplished individual carries with them a journey of dedication, knowledge, and meaningful contribution. Before we hear from our guest of honor, let us take a moment to learn about his remarkable academic and professional journey. I now invite Mr. Prateek Deb, 4th semester, BBA LLB, Christ Academy Institute of Law, for the profile reading.
Good morning, everyone. It is a great honor and privilege to introduce our esteemed guest for today, Dr. Sathish Gowda. Dr. Sathish Gowda is a distinguished academician and legal scholar with more than 17 years of teaching experience at both undergraduate and postgraduate levels. He is currently serving as the Dean, Faculty of Law at Bangalore University, and also as a Dean, Faculty of Law at Cologne University. He has also served as a former Registrar of Tumakuru University. He completed his LLM in Constitutional Law, Business and Trade Law with first class and obtained his PhD in Constitutional Law in 2012. His academic excellence is reflected through his university ranks, distinctions in law education. Dr. Gowda has published more than 50 research articles in reputed law journals and newspapers and has successfully guided 7 PhD scholars. He has delivered lectures and participated in academic programs at prestigious institutions and organizations, including Harvard Law School, Georgetown University Law Center, the United Nations, and the International Court of Justice, along with universities across countries such as China, Germany, Sri Lanka, and Bangladesh. In recognition of his service and leadership, he received the Best NSS Coordinator State Award for the year 2021 and 2022 from the Honorable Governor of Karnataka. He has also been honored with the Young Scientist Social Science Award for Outstanding Research at an international conference. I request all of you to join me in extending a warm and gracious welcome to Dr. Sathish Gowda and invite him to address the gathering.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. Good morning to one and all, respected dignitaries, all and of the dais, today's chief guest, my teacher, my mentor, a dynamic leader, Hon'ble Vice Chancellor, Professor Dr. C. Basavaraju sir, and today's president of this program, Reverend Father Thomas Chakramakil, and a dynamic principal of this esteemed institution, Father Davies sir, and coordinator of the program, Dr. Sini Madam, Dr. Nandu Sam Jose, convener, and my dear friend, Dr. Avinash, and today's resource person, Professor Jaidevan Nair sir, Professor K.B. Kempegowda sir, Professor Rahul Mishra sir, and all the respected faculty members, and my dear student conference on contemporary challenges to governance and rule of law. Governance can be discussed in different perceptions and perspectives. Governance can be nurtured through OTP. OTP is not one-time password. It is openness, transparency, and participation. But this OTP that depends upon the participation. Wherever I go, I keep telling, democracy demands participation. The quality of participation depends upon quality of awareness. The quality of awareness depends upon quality of information. Action, reaction, interaction, overaction, non-action of the government can be questioned through RTI. And the quality of information depends upon quality of education. The quality of education depends upon quality of democracy. It is pertinent to remember one of the important statements made by Lord Montesquieu. He wrote a book in 1748. It is titled as The Spirit of Law, where he mentioned democracy works when people are intelligent. Otherwise, it is worse than tyranny. If I take comparatively with UK, with India, in UK, though there is no effective judicial review, effective federalism, and separation of power, still they uphold rule of law, means they give much importance to the public review than judicial review. Ensuring governance in the nation like India is not an easy task. I keep telling, wherever I go, India cannot be compared with any other nation in the world, for simple reason that we have unlimited population with limited resource, whereas if you go to the European Union and other developed countries, they have unlimited resource with limited population. So ensuring governance, that too country with diversity, is not an easy task. It can be discussed in different perspectives: digital governance, judicial governance, election commission, many issues. So, when it comes to the governance, we have to think in a top level. Instead of correcting in the bottom level, we have to correct in the top level. Why I am telling this? If you just go for the composition of parliament, recently the statistics revealed by ADR, Association for Democratic Rights, where they mentioned almost out of 543 MPs, 92% people are crorepathi's. Who constitute major in the nation like India? If I take the vulnerable sections of the society like scheduled caste, scheduled tribe, OBC, farmers, laborers, unorganized laborers, person with disabilities, children, women, senior citizen, altogether they constitute 90 to 95%, but their representation in parliament even not less than 5%. But you have only few elite class, less than 5% are there. their representation or their 95% representations are there in parliament. Just you have to introspect whether we are really in the true democratic world. How are they going to ensure governance? Professor Basavaraju sir, my guru, he used to say, he was just emphasizing on direct principle of state policy. I think according to me, because of judicial governance, it makes no difference, part 3, part 4. All part 4 aspects have been transferred to the part 3 by virtue of Article 21. Article 21 is like a Chinnaswamy Kridangana for the judges who batted and interpreted and brought so many unenumerated fundamental rights. When it comes to governance issues, as I told you, in the parliament, first thing is parliament composition. And again, when it comes to judicial review, see, we are, in India, judicial review is very strong, but public review is very weak. Go to UK, king can do no wrong because the constant observation by the people where the Prime Minister cannot do anything against the rule of law. The beauty of UK, though they do not have judicial review, federalism and separation of power, still they uphold rule of law in the sense, imagine having all this separation of power, federalism, judicial review in a country like India, still we are not in a position to uphold rule of law in the sense we have to introspect. Absence of these 3 important items in the constitution like UK, I think it is really difficult for us to uphold rule of law, number 1. Number 2, coming to the governance, the representation of women. This government somehow in 2023, they introduced 33% women reservation. It was amended and now about to implement. But see that, just I will take one example where in 1997, in Vishaka versus state of Rajasthan, judiciary through its judicial activism, through its governance, they laid down the guidelines by invoking the important provisions under CEDA, Convention Against Elimination of All Forms of Discrimination Against Women. This judgment came in 1997, but there was no specific law to prevent sexual harassment of women at workplace. But later, after 16 years, it was enacted in the parliament in 2013. If there were 33% reservation by that time, if women participated in the parliament, it would have been enacted within next year of this judgment. So there also we have to introspect about the governance. In that respect, we have to appreciate the role played by the Indian judiciary through its judicial activism. One of the statements made by Justice P.N. Bhagavati, he says, judge infuses life and blood into the dry skeleton provided by the legislature, create living organism appropriate and adequate to meet the needs of the society. Whenever the legislature and executive fail to discharge their duties and function in accordance with the constitution, then judicial governance very much required to protect, promote and ensure the basic fundamental rights guaranteed to the citizen of this country. And when it comes to 2 best institutions, entire rule of law, democracy, whatever you call it, governance, it is vested upon these 2 very important institutions. It is a need of our to introspect about the appointment of these 2 bodies. Number 1, Election Commission, Chief Election Commission and Election Commission, and collegium system. What is the constitution basis for collegium? We have to introspect. In Anup Shah Barnwal versus Union of India, a activist advocate who filed a public investigation questioning the constitutional validity of the union government's unilateral power to appoint CEC and ECS, Chief Election Commission and Election Commission. There, until the law made in this behalf, Supreme Court has directed to constitute a committee to appoint these highest constitution bodies consisting the Prime Minister, Opposition Leader and Chief Justice of India. But again, living Chief Justice of India, Opposition Leader, Prime Minister and one more minister having cabinet rank have been constituted. Again, it was challenged in 2020. It is before the court. That has to be taken into consideration in very serious way. Because who wins the election, who rules, they rule the nation. They rule the nation, so we have to be very specific about the appointment of CEC and ECS. Then when it comes to appointment of judges of Supreme Court, right from 1952 till now, 4 important cases you might have heard about. S.P. Gupta's case, Supreme Court on Record Advocate Association, and in presidential reference, and finally again in 2015, they bulldozer the 99th Amendment, which affect one of the important basic structure doctrines, that is subject matter, that is independent judiciary. Considering that, they declared 99th Amendment is unconstitutional. Again, we have to think about whether collegium system is really working effectively and efficiently to ensure, because Dr. B.R. Ambedkar says, if you ask me which is the best article in the Constitution, my answer will be Article 32, that is heart and soul of our Indian Constitution, he mentions. But that heart beats only elite classes, not to the poor sections of the society. Like Shankari Prasad, Sajjan Singh, Golaknath, Keshavananda Bharati, they are all elite people who can go to the Supreme Court. What about the vulnerable sections of the society like farmers, labor, weaker section of the society? What is their percentage regarding the access to justice when they go to the Supreme Court? Supreme Court conferred. Forget about going to Supreme Court. They don't have competency to even access to the taluk courts. That we have to introspect. Then again, one should read the book written by Rajiv Dhawan. It is titled as Constitution of India is a Miracle, Surrender and Hopes. Why it is miracle? Because see the diversity. If you go to any country in the world, you find major 2 religions. One is Christianity and Muslim. In Christianity, Protestant Catholics are there. In Muslim, Shia and Sunni are there. But come to India, we have Shia, Sunni, Protestant, Catholics, Hindu, Sikh, all Buddhist, all type of people are there. One constitution is working. Is it not a miracle? Drafting one religion, drafting a constitution constitution to one religion is a very difficult task, in the sense drafting constitution to multi-religious, multilinguistic, multicultural, a country with diversity, it is not an easy task. So we all have to introspect. One last example I wanted to give you. To ensure further good governance in the federal perspective, they introduced 73rd and 74th Amendment in 1992-93. Almost we have completed the 3 decades, 30 years. Earlier position before 73rd, 74th Amendment, our villages are they were having full of ponds, lakes and water bodies, and somehow it was. But today, see the state of affairs in village. If you go to village, lakes are vanished, no water bodies. What the local self-government is doing, Gram Panchayati, the Taluk Panchayati and Jilla Panchayati. And till today, if you go to the village, same drainage, same garbage, no governance. These are all things to be discussed in this wonderful platform. I hope there will be wonderful deliberation discussions in this conference. I wish you all the very best for Christ Academy for selecting a wonderful topic with relevance. Thank you one and all for great opportunity. Namaskara.
Thank you, sir, for your insightful address and for sharing your valuable academic and legal perspectives with us. Your reflections on the contemporary challenges faced by legal system and institutions have added immense depth to our today's discussion. Books are more than collection of pages and words. They are a reflection of thought, research, dialogue, and collective intellectual effort. We shall now proceed to the book release ceremony of the edited volume titled Migrants and Displaced Persons, Protection of Human Rights and Challenges, the Meliora 6 edited book. It stands as a testament to meaningful academic collaboration and the continued commitment towards research and legal scholarship. May I now request the dignitaries on the dais and the editors of the book to kindly join us for the official release of the book. I request Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, Hubballi, to kindly hand over the first copy of the book to Reverend Father Thomas Chakramakil, CMI, Manager, Christ Academy Educational Institutions. I request the Honorable Vice Chancellor to kindly release the seminar proceedings of Ad Meliora 7 and hand it over to Dr. Sathish Gowda N. We congratulate everyone who has contributed to these scholarly works and appreciate their efforts and dedication towards academic research and publication. A keynote address often sets the intellectual depth and broader perspective for a conference, offering insights that inspire reflection and meaningful discussion. Before we hear from our distinguished keynote speaker, let us take a moment to learn about his remarkable academic and professional journey. I now invite Ms. Mithka Maria Pradeep, student member, Academic Outreach Committee, Christ Academy Institute of Law, for the profile reading of our keynote speaker.
Good morning, everyone. It is my immense privilege and honor to introduce our esteemed keynote speaker for today, Professor Dr. Kirk W. Yonker, Chair of the U.S. Law at the University of Cologne and Vice Rector for Sustainability. Professor Yonker is an internationally acclaimed academician, researcher, and legal scholar who began his academic journey at Pennsylvania State University, after which he earned his Juris Doctor from Duquesne University School of Law and later completed his PhD at the University of Pittsburgh. He also pursued advanced studies in German law at the University of Tübingen and served as a postdoctoral fellow at the University of Bonn, as well as the Ministry of Justice in North Rhine-Westphalia, Germany. Before entering academia full-time, Professor Yonker served as an environmental litigation counsel for nearly 10 years with the Pennsylvania Department of Environmental Protection in the United States, where he represented the department from before local, state, and federal courts. Professor Yonker's academic career has been truly international in character. He has taught at several respected institutions across the United States, the United Kingdom, and Ireland. He served as a faculty member at the Open University in the United Kingdom and later held the first cross-border academic appointment in Ireland, simultaneously teaching at Queen's University Belfast and Dublin City University. He also served as an associate professor at Duquesne University School of Law and as a project advisor to the European Commission, contributed to major international research collaborations, and played a foundational role in European science communication networks such as NSCOT and ENSCO. He is also the co-editor of several internationally respected publications, including Comparative Environmental Law and Regulation and Environmental Policy and Law. Over the years, his excellence in research has been recognized through grants and fellowships from prestigious institutions, including the European Commission, the German Federal Ministry of Education and Research, the British Council, the Royal Irish Academy, and the University of Pittsburgh. With his remarkable blend of academic excellence, practical legal experience, and global perspective, Professor Yonker brings invaluable insights to today's discussion. Sir could not join us in person today, but we are delighted to have him join us online for the session. I request all of you to please join me in giving a warm and gracious welcome to Professor Dr. Kirk W. Yanker. I now request Sir to kindly take over the keynote session. Thank you.
Thank you very much for your introduction. And I'm hoping that the transmission of the words I'm about to present is clear. I'll try to speak slowly because I think there's a bit of a delay. I'm very happy to be with you, at least virtually. And as was mentioned, I also hold the title of being the Vice Rector for Sustainability. So I would love to have been with you today, but it is in fact more sustainable for me not to fly from Europe to India to give this address. And so I hope that my inability to do so is also a positive thing regarding sustainability. I also want to thank the organizers, especially my colleague, Mr. Vikas Galot, with whom I have the pleasure of working before and with whom I am currently editing a book in comparative law. It's comparative conservation law. And we take the position, as a matter of comparative law, that India is the base state. And as your colleague just mentioned, with a keynote address, one could even go so far as to say, we use India's conservation law then as the keynote to compare other states to India. This is, if you look into the history of comparative law, a relatively new approach because far too often comparative law is based on what happens either in Europe or in North America, and then what happens in Asia, Africa, or Latin America is not the base state, but the compared state. So we've reversed that for the work. I have 2 points to make in my remarks to an audience of students and scholars. The first set of points regards legal practice, and the second set of points regards legal education. First, legal practice, because most people in legal education, that is the students in legal education, want to become practicing lawyers, and so this applies to them as much as legal education does. When law is an expression of will, that is the will of the citizens, and exercised by the citizens, as demonstrated by their exercise of rights and their acceptance of liabilities, then it's a powerful social organizing force. But when any of these 3 factors is lacking, that is either the norms and procedures are not the expression of the citizens, or the legal system is ignored by the citizens and disputes are settled in other ways, or citizens do not accept legally determined liabilities, then the law is in fact weak and fragile. As you may be able to tell from my accent, although I have lived and worked in Germany for a long time, I began my life in the United States of America. These observations today are from 40 years of legal practice and education on 5 different continents. We might use these 3 criteria that I have listed to look, however, not just at the US culture right now, but to consider whether law is a strong or fragile force in any system, India, the United States, or Germany. From the outside, for instance, Germans often ask if US law or the US Constitution is in crisis. They look at the behavior of the US president and his supporters for evidence. They look at that behavior abroad because, after all, he is the head of state as well as the head of government. So they look at wars and they look at trade tariffs in countries foreign to the USA. But if we look instead for evidence to answer the question, in the daily practices of law, what do we see? When someone buys a washing machine in Wisconsin or Kolkata, and the machine malfunctions, will he or she go to court and exercise contractual rights? If, for instance, in the United States state of Missouri, someone steals an automobile, the police arrest the person and prosecute the person, will the person get a fair trial? And if a couple divorces in the state of New Hampshire and disagrees over custody of the children, does the couple take their dispute before a judge and accept the judge's decision? The answer to all of these questions is yes. And the statistics by the United States Department of Justice or the Pew Charitable Trust, as an outside observer, demonstrate that the answer is still yes, despite what is seen by leadership in the office of the President of the United States. But the question of whether a legal system is in crisis when raised by persons outside the system, and this is where comparative law becomes an important activity for persons in India, as the colleagues have just presented, looking at the United Kingdom, for instance, or Europe, or the United States. They're looking instead for evidence from observing the behavior of its leaders. And this is an important thing to keep in mind. That is lacking in the US, and it's also lacking in other places at present. This attitude of strong men who function outside the law is a manifestation of populism. Populism is not a new phenomenon. It's not a new phenomenon in the United States, where it occurred before. There was actually a populist party in the United States. They named themselves that in the 1890s. Populism in Argentina existed in the 1930s, and today's president is well recognized as being a populist president. It existed in Europe with Berlusconi in Italy. It existed in Brazil with Jair Bolsonaro. It exists in Turkey today. So populism isn't something new. Populism is something that we have to observe, and as scholars of the law, work out what do we do with populism in governance and the rule of law. The challenge is whether those who buy the washing machine, steal cars, and desire custody of their children after a divorce will remain exercising their rights and accepting liabilities, or will they resort to the non-legal practices of the populist leaders? And this is the only thing I want to say about legal practice today, is when we're talking about whether states are in crisis and whether governance is a problem, we need to be looking, as the colleagues have already commented, we need to be looking on what you will do in the daily practice of law, not at what the leaders do from their elevated positions, because that has not been the best example, for instance, in the United States right now. But let me transition for the second part of my remarks to legal education. In discussing my second point, legal education, I have 3 sub-points to make. First of all, scholarship is not journalism. Secondly, education is impossible if one is a non-cognitivist about values and the law. And third, educating and training lawyers means preparing scholars to enable all citizens, not just wealthy citizens and corporations, to exercise their rights and defend their liabilities. Let me say a few words then about scholarship not being journalism. In many areas of the law, including constitutional law and my own area of practice, experience, and research, which is, as has been mentioned, environmental law, scholars are pressured to always know the latest legislation or know the latest court decision, and then confidently tell the client or publish the article that uses this news to accurately predict future court decisions, risks of liability, and ripe moments for asserting rights. But scholars are not news journalists. The skill of scholarship for the legal scholar is to observe events in many contexts, especially the context of larger periods of time. That's also a comparative law issue. The context of other legal cultures, that's the standard comparative law context, but also the context of other disciplines. We're a bit insular as lawyers sometimes. Other disciplines are also trying to solve the same or similar problems. And here I don't simply mean the technocrats in economy or policy or politics. I mean sociologists, anthropologists, and psychologists. Interdisciplinary work with these people can help good governance and the rule of law as well, and in fact does all the time when we work together with these people. This is the way the client, this is the way the citizen experiences his or her activity in law. The second subpoint I want to make then is the one that I have named non-cognitivism. In reviewing the 12 proposed sub-themes for this conference and the presentation titles for the papers today and tomorrow, I'm impressed by the timeliness of many of the themes, but two of them in particular among the 12 struck me especially. Of course, the theme of environmental justice, because this is my work. But in addition to that, the theme called socio-political challenges to governance and democratic values. This particular theme I found to be of particular relevance because it touches upon the notion of misinformation. And this exposes a social trend that shakes the very core of all information, which shakes the very core of all education, including legal education. In the past, and I'm old enough to really be the old white guy in the room here. I'm very aware of that. But in the past, I recall pre-internet, if you can believe that. It's difficult for you, probably for the students in the room, to think about pre-artificial intelligence. I can even talk about what it was to practice law or teach law pre-internet. I recall having once been puzzled because I asked in class what a student's source was for a point that she had made regarding, in fact, professional responsibility of lawyers. And her answer was simply the internet. As I said, this was pre-artificial intelligence. Simply about the internet alone, I tried to politely point out that the internet is simply a medium of transmission. It is not a source. The production of knowledge is not present necessarily just because something was on the internet. There has not been peer review. There's not been the scientific process that gives quality to the information, quality to the knowledge. That confusion exposed an early crack in the foundation of understanding knowledge production. The promise of the internet, and I can tell you this from my own experience, was the democratization of knowledge. That was naive. As artificial intelligence now, and the artificial intelligence fixation that all cultures have demonstrates, the internet is largely marketing. It's marketing through any means, real or fake, and that produces mistrust, and it produces confusion, and it drives citizens away from systematic knowledge production and instead to strong leaders, to strong men. In Cologne, at the University of Cologne, where I am Pro-Rector for Sustainability, but also Professor of Law, we recently had a guest who had worked in the first Trump presidential administration in the United States. And although he remains faithful to the conservative agenda of the Republican Party and some of the policies of Donald Trump, he admitted that the first Trump administration, and he was there, he worked in the wing of the White House with all the people that are still in the news in the second Trump administration. He admitted in the first Trump administration there was an explicit, intentional strategy to destabilize knowledge and to leave citizens in the non-cognitivist state of believing knowledge is not possible. Through this intention, or through artificial intelligence or anywhere else, knowledge was not possible. By creating this intentional chaos and confusion, one is left, therefore, as a citizen, with no choice except to follow the strong leader, because knowledge is impossible. A study of law focused upon legitimate knowledge production through live discourse and live discussion and debate, such as today and tomorrow at the Ad Meliora 7 conference, is a way to stop this non-cognitivist strategy that the state, or a state like the United States, may actually actively be engaged in. My final point then regarding education, and my final point today from me is regarding lawyers, is that what the students in the room are experiencing and will be experiencing for several semesters more is not job training. There's a reason why law students are tested by the state in order to become persons who may represent the rights and liabilities of others. And I could give an example from Germany. More than 100 years ago, Otto von Bismarck, the imperial chancellor, recognized this himself. And he opened all universities to anyone who wanted to study education or anyone who wanted to study law, because they are both in the service of citizens, and we can't have too many of them. But they are in the service of citizens. And for that reason, it's the state as an institution representing citizens that is interested in lawyers' public role, not in job training, but in the public role of lawyers, representing other persons' rights and liabilities. This isn't true for private business. We lawyers do tend to volunteer to look like private businessmen and women, and here I am sitting here wearing a necktie and a jacket, and many of you are doing the same thing. But that reminds me of the Greek Prime Minister several years back, Alexis Tsipras, who refused to wear a necktie because he said it was the representation of business, and he was not a businessman. He was a government leader. Despite that, at a European Union meeting on the stage, Silvio Berlusconi handed him a necktie for the international community to see, because he said he wasn't behaving as a state leader because he wasn't dressed as a man for business wearing a necktie. Despite that appearance, we are public actors. We're serving citizens, even when the citizens happen to be wealthy persons or corporations. So with that, and for this morning's session, then I would like to conclude where I began, that in the practice of law, we see what is really happening not by leaders of one's state as political actors who may ignore the law and are looked to, especially in comparative law, by people from the outside because that's what they see in the international media, but rather what is happening in the practice of law by the citizens. Do they still go to you, the lawyer, if they've made a purchase for a simple consumer good and they want the contract to be honored? Do they go to you for the settlement of family matters, with a divorce or child custody? Do they go to you in criminal matters? Or do they try to work outside the legal system because they have no trust in the legal system? That is understanding whether the practice of law is in crisis. Secondly, legal education. The 3 points that I made were, we're not journalists. Scholars need the context of analyzing and evaluating over time what the trends may be before digesting it and giving real counsel to clients, before providing real knowledge to other scholars and students. Second, we have to struggle against non-cognitivism. I'm afraid that artificial intelligence and the internet generally make it look as though anything that is available under the guise of information is equally as legitimate as anything else, and this is an intentional attempt to confuse people or to just lead them to buy something. And finally, my last point for us today is that we have to remember that legal education is not job training as if we're business persons. They are not subject to state testing because the state, on behalf of the citizens, doesn't really have a particular interest in what happens in private business. It does have an interest in the practice of law because the practice of law does concern the rights and liabilities of other persons. We heard from Father earlier today that a tribal person, for taking 200 rupees worth of rice, could spend life in prison. Who's representing that person? That's the job of the lawyer. Thank you very much for the opportunity to speak with you on comparative law, for some perspectives from Germany, from the United States, put together with the perspectives which, as your colleague earlier called us, the fraternity of lawyers worldwide. Thank you.
Thank you, sir, for your deeply enriching keynote address. Your insights into governance, legal system, and the contemporary challenges to the rule of law have provided us with a broader global perspectives and much more to reflect on as we continue with this conference. Gratitude is not only the greatest of virtues, but the parent of all others. As we near the conclusion of this inaugural session, we take a moment to express our sincere gratitude to all those whose presence, guidance, and contributions have made this gathering meaningful and successful. To formally deliver the vote of thanks, I now invite Ms. Geetanjali Surjit, Student Convener, Academic Outreach Committee, Christ Academy Institute of Law.
I quote, I would maintain that thanks are the highest form of thought and that gratitude is happiness doubled by wonder. I unquote. Standing here at the successful inauguration of Meliora 7, International Conference on Contemporary Challenges to Governance and Rule of Law, my mind is indeed filled with that exact wonder and deep gratitude. Good morning, respected dignitaries, faculty, and my fellow students. I, Geetanjali Surjit, Student Convener of Academic Outreach Committee, consider it as my absolute privilege to propose vote of thanks for the inaugural session of Meliora 7. First and foremost, I would like to extend my deepest and most sincere gratitude to our chief guest, Professor Dr. C. Basavaraju, Vice Chancellor of Karnataka State Law University. Sir, we recognize that leading the state's premier law university comes with an incredibly demanding schedule. We are deeply humbled and grateful that you chose to carve time out of your busy commitments to grace this occasion. Thank you for your enlightening inaugural address, which has set the profound tone for this conference. Thank you, sir. I also extend our sincere thanks to Professor Dr. Sathish Gowda N., Dean and Faculty of Law at Bangalore University. Sir, it is an absolute privilege to hear from a scholar with such a distinguished international academic presence and a deep mastery of constitutional law. Thank you for your invaluable special address. We are highly obliged by your time and your insights. Thank you, sir. A profound appreciation goes to Professor Dr. Kirk W. Juncker, Professor of Law and Vice Rector of Sustainability, University of Cologne, Germany, for delivering such a profound keynote address. Sir, your unique cross-border academic experience and deep expertise in international law have truly set the perfect intellectual tone for this conference. We are deeply grateful for the global perspective you have shared with us today. Thank you, sir. Our deepest respects and thanks goes to our manager, Reverend Father Thomas Chakramakil CMI, for his inspiring presidential address and for being our constant pillar of support. Thank you, Father. I extend a heartfelt appreciation to our principal, Professor Dr. Father Davis P.V. CMI, for his guiding words in the principal's address. Thank you, Father. A very special thanks goes to our Vice Principal, Dr. Sini John, for being with us through each and every step towards the execution of this event. Thank you, ma'am. I also express our deepest gratitude to our Academic Outreach Committee Faculty Convener, Dr. Nandu Samjos, all other faculty and student members of the committee for your tireless effort. Thank you all. A heartfelt thank you to all the esteemed faculty members of our institutions. Thanks for your moral support and encouraging presence. Thank you. Last but certainly not the least, a token of gratitude to the entire technical and support team. Thank you. Finally, my heartfelt thank you to all my fellow students seated in the audience. Thank you. Thank you, everyone. We look forward to highly engaging sessions ahead. Thank you.
Thank you for your heartfelt words of gratitude and acknowledgement. With this, we come to the close of the inaugural session of Meliora 7. Today's gathering has been far more than ceremonial beginning. It has been a meaningful coming together of ideas, perspectives, and shared responsibility towards understanding the contemporary challenges to governance and rule of law. The insightful addresses, thoughtful reflection, and academic exchange witnessed today have truly set the tone for an enriching conference ahead. We extend our heartfelt gratitude to all the dignitaries, esteemed speaker, respected faculty members, participants, and organizers whose presence and contribution made this inaugural session both memorable and inspiring. As we move forward with the conference, may the discussions initiated today continue to encourage critical thinking, meaningful dialogue, and a deeper commitment towards justice, accountability, and responsible governance in our society. May this platform inspire not only an academic inquiry, but also thoughtful action and collective responsibility in addressing the evolving challenges of our time. I now request everyone to kindly rise for the college anthem, followed by the state anthem and the national anthem.
Jaya Bharata Jananiya Tanujate, Jaya He Karnataka Mate, Jaya Sundara Nadi Vanagala Nade, Jaya He Rasa Rushigala Bide. Bhudeviya Makutada Navamaniye, Gandhara Chandada Honnina Ganiye, Raghava Madhusudana Ravatayisida जनमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you all, wishing you a meaningful and enriching conference ahead. I kindly request everyone to reassemble in the auditorium by 11:20 a.m. for the panel discussion session. The second attendance will be taken sharp at 11:20. We look forward to your continued participation. I request all the committee members to kindly stay back for a photo shoot.
Check, check, check.